All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you. You may be seated. Good morning. I am Hunter Murphy. We are here for the case of Farm Bureau versus Kerby et al., docket number 20-883. With me today, to my right, is Judge Toby Hampson. To my left, Judge Darren Jackson. I believe there has been some conversation with the clerk's office about avoiding use of the minor child's name. I'd also ask you to avoid use of the minor child's mother's name, which appears at portions. If you can avoid it, that would be a better practice than not. But if it cannot be avoided, that's something we'll deal with. And would you like to reserve any time for rebuttal, sir?
Yes, Your Honor, 5 minutes.
5 minutes. Thank you. You may begin.
May it please the court. My name is Bill Moore. I represent the nominal defendants, E.M. and Morgan, in both the underlying case which they brought in Gaston County against Karen Kerby and Karen's Daycare, and as defendants in the action before this court, a declaratory judgment brought by North Carolina Farm Bureau against Karen Kerby individually and doing business as Karen's Daycare, the Morgan defendants, and the deceased Robert Kerby. On behalf of my clients, I would ask the court to take a look at what's been done and to reverse the trial court's grant of summary judgment for disregard of clear precedent in a published opinion issued by this Court of Appeals and opinions cited therein, that is in the Farm Bureau versus Cox case, as well as the Supreme Court's decision in State Capital versus State Capital Insurance Company versus Nationwide. And the reason is that of course, the standard of review for this court is a de novo review, so I'm really out of order in presenting a summary judgment defense, but that's the posture that we're here in. Nonetheless, the trial court did not apply the proper standard of review. As is recognized, summary judgment at this stage, given a declaratory judgment action, requires that the facts which were drawn from the pleadings, the depositions, and the materials, as in the Cox case, must be considered, and the facts that support the Morgan defendant's position must be treated as true or deemed to be true for the purpose of determining whether or not there's a duty to defend under the insurance policies.
So since we're in the summary judgment posture that we are, is it your contention that there are any genuine issues of material fact that preclude summary judgment really for either party, or is this a case where summary judgment was proper for somebody, there are no disputed facts, it's purely a question of law?
There are genuine issues of material fact in the underlying action. There are no disputes about the policy language that is at issue, and there should not be any dispute about what is contained as the allegations in the amended complaint filed by the Morgan plaintiffs there against Karen's Daycare and Karen Kerby only. So while it's possible that we could disagree about what the exclusions mean and could have a genuine or material issue of fact on a genuine issue as to the extent of the coverage or whether there would be indemnity coverage, that was a premature decision by the trial court because you can't really decide whether there's coverage. Coverage is for a judgment on a lawful claim entered in the underlying action. And until the jury sorts out exactly what was done and what the true facts of the case are, it can't be determined that there is no coverage or that there is coverage. In that sense, there is a genuine issue. However, I believe Your Honor is correct in suggesting under these circumstances as a declaratory judgment, and if the law of North Carolina is to be followed on contract interpretation, but particularly on insurance contract interpretation, then the summary judgment should be reversed, and summary judgment is, in fact, appropriate for the defendants on the duty to defend. Now, whether there is a duty to indemnify is not discernible at this stage because many things could happen, as happened in the Cox case, where same counsel, same insurance company, same argument on exclusion was determined not to preclude the duty to defend negligent infliction or infliction of emotional distress claims against an insured just because there had been a sexual molestation by someone else in the household, committed by someone else in the household. Very similar facts, except they only had one policy. In this case, we had two, both the homeowner's policy and the commercial lines general liability policy for the daycare, both issued simultaneously, recognizing that there was a daycare business in this home and insuring Karen Kerby doing business as Karen's Daycare and insuring both Karen Kerby and Robert Kerby for their home, for the homeowner's policy. Now, Robert Kerby, we learned, was not an employee, did not work for the daycare, and had no ownership interest in the daycare. Yet, he is the sole basis for Farm Bureau's argument that there can be no coverage because he admitted guilt to one count of indecent liberties among many that were brought, and that somehow transfers all exclusion to the claims because there was an act of taking indecent liberties. That, however, was not what was alleged in Cox, and in that case, this court reversed a grant of summary judgment and specifically held in a published opinion that there was a duty to defend and that the sexual molestation, the same exact phrase used in the homeowner's policy in this case, did not preclude other proximate causes for covered injuries, including specifically infliction of emotional distress. Mr. Kerby is not even a party to the underlying action. He's not sued there, and he's passed away some 3 months before summary judgment was heard. By the way, I want to apologize to the court for any reference to the minor, but I also would explain she has come of age. She is now over 18, and being my client, she was not seeking to keep her name limited to initials. So I don't know if that makes a difference, but I'll respond to the order we received this morning accordingly. Still, it's critical that the construction of insurance contracts be followed in a declaratory judgment action to determine whether there's a duty to defend, or possibly, if as a matter of law there is no coverage because there could not be coverage. But we're talking about construing an exclusion to an insurance policy, which means, of course, under Harleysville Mutual Insurance Company versus Buzz-Off Insect Shield, LLC, the Supreme Court case 364 NC1, first cited by Cox in the opinion. You have to use the rules of construction applicable to insurance contracts, which means insurance coverage, which is the object, the party's intent in entering the contract is to pay a premium and receive insurance coverage. And so coverage terms must be construed broadly. Exclusions must be construed narrowly, and they are not favored, nor are the exceptions, but to the end that if there's any ambiguity or any question at all, coverage should be found. That's the purpose of the contract. That principle was disregarded along with this court's decision in Cox, along with the Supreme Court's decision in state capital, which makes it very clear that coverage under a liability insurance policy is equally available to an insured whenever an insured risk constitutes simply a concurrent proximate cause of the injury. Concurrent proximate cause, a well-established principle in our law. The case goes on to, the Supreme Court goes on to say that multiple causes may have effectuated the loss does not negate any single cause, that multiple acts concurred in the infliction of injury does not nullify any single contributory act. When an accident has more than one cause, one of which is covered by an insurance policy and the other which is not, the insurer must provide coverage. As a general rule, coverage will extend when damage results from more than one cause, even though one of the causes is specifically excluded.
Let me just ask a couple of housekeeping questions. I just want to make sure I'm positive of. In
Yes, sir.
both insurance policies that are at issue here, Mr. Kerby was a named insured, correct?
Well, he is listed, but he is wrongly listed under the facts, so there's a genuine issue of fact in this case, whether he is an insured under Karen's daycare, because Karen Kerby testified in her deposition that he had no ownership interest, that he was not an employee, that he did not work for the daycare, and that she had never utilized him as an agent. Now, there are other facts that show she also allowed him to photograph the children in costume as part of the services provided by the daycare, and some of which activities took place in the home, not daycare facility, and others involved the daycare, but it was all on daycare equipment, cameras owned by the daycare, internet account owned by the daycare, which is normal for folks to run their business expenses that are in the same home as, so.
Within the four corners of both policies, he is a named insured, though, correct?
Yes, but he is not a
I
party.
guess one of the issues that I keep tripping up on is applying Plum Properties and waste management.
I'm sorry?
Applying Plum Properties and waste management. Applying those two cases and their definition of what an occurrence is and what is an accident. How does this become an accident? Setting Cox aside, assume for a minute that we don't believe Cox is as precedential and or we don't find it persuasive, even if it's not precedential. Assuming we're just looking at Plum Properties and we're just looking at waste management. How is this an accident, given the terms as they're defined by the Supreme Court?
Karen Kerby had been advised by other children that taking photographs was making them uncomfortable, or that her husband had crossed the line in various ways. She disregarded that. She was visited by the DSS, the Department of Health and Social Services for the county, who said, you can't let the kids go upstairs unattended and for the purpose of taking pictures. and you can't have your husband around. He's not trained, he's not supervised, he's not employed. So she called him off of that, and they stopped for a few months. And then once the Cherryville Police Department, I believe it was, decided that there was no case against Mr. Kerby by the child who had reported both to the police and the DSS, things went back to normal. There were more pictures taken. And the real reason is because in the home, those parts that were utilized were being used by Mr. Kerby and or Mrs. Kerby, both of whom were personal friends of the plaintiffs. As in the Cox case, there were personal assurances. These folks had a relationship that was beyond just the commercial. And so some of the actions that took place, nonetheless, were while the child was in the care and custody of Karen Kerby. Whether that was as a friend of her mother's or as a daycare operator gets a little blurry because the events didn't take place all on daycare premises. And there were other times when she would be an authority figure. It also goes to the cause of the injuries. It's not all caused by a single indecent liberties, which is the only thing Mr. Kerby pleaded guilty to. But he's not possibly going to give rise to a coverage question. He's not a named defendant in the underlying suit. So whatever he might have been excluded from has nothing to do with whether Karen Kerby was negligent, neglected the children, negligent in supervising, negligent in allowing them to go off the daycare premises, negligent in not supervising as a friend of the mother who had made assurances that this was a safe environment and had made assurances that her husband was not, did not have a propensity for such lascivious acts. She had 4 warnings for over a course of years and denied to the Morgan family that there was anything to it. And they believed her, but she negligently allowed the children to be exposed to what was a hidden danger. It could have been a loose plank going up the steps, but it also involves...
But a loose plank is a condition. It doesn't require an intentional act by someone else later. So when you're comparing the negligence in letting somebody go upstairs, there's not, for lack of a better word, an occurrence that caused the bodily injury until that person chose to act and committed a willful act.
I disagree, Your Honor. Bodily injury includes mental distress. The mental distress in this case was not simply from the physical acts. The mental distress that both, well, particularly Beth Morgan sustained, because she was never touched, never had any interaction with Mr. Kerby in that way, but she suffered emotional distress because for years Karen Kerby had instilled her discipline, had gained trust of both the mother and the daughter, had in fact participated in grooming, and the real pain associated with a victim of exploitation, whether it's abuse, which is the broadest sense used, or otherwise, the real harm is in the guilt, in the feeling like I went along with this, in the betrayal of the trust by authority figures who, and that may never be regained. This individual may never be able to trust an authority figure again, may never be able to trust a person dating or a mate, and those problems, and our underlying complaint does include those damages. They didn't come from anything Robert Kerby did physically, or more to the point, to borrow from my esteemed colleague's argument, anything he pleaded guilty to as an intentional act, or as sexual molestation, or as abuse, and excuse me, the specifics that are listed make it clear that the terms are ambiguous, arising out of sexual molestation, corporal punishment, or physical or mental abuse under the homeowner's policy, arising out of actual or threatened abuse or molestation, any type of abuse or molestation, by anyone of any person while in the care, custody, or control of any insured. That's the daycare's coverage. A daycare's coverage. What would any normal person assume insurance coverage for a daycare to exclude? The one thing that would not be on their minds, on anyone's, and certainly is covered by this definition, but everything is covered by this definition. In fact, interestingly, there's a particular quote that comes from, I believe it was Madison, that says, abuse, any abuse is actually from the use, that the use of, any proper use includes abuse, because that's simply the line of what is permitted. And in that particular case, Renwick versus News and Observer Publishing Company, Supreme Court case from 1984, James Madison, stated, quote, "Some degree of abuse is inseparable from the proper use of everything." Now, they were concerned there with the press, but nonetheless, in this case, there were claims and are claims in the underlying case for the exploitation of taking pictures. Now, the pictures aren't in evidence. They're not necessarily pornographic, but the reports to the police included various stages of undress and possibly were taken without the children's knowledge, certainly without the parents' knowledge, while they were changing clothes upstairs because they were unsupervised, yet under the facility of the daycare. They were unsupervised by Karen Kerby, whether she was responsible as the daycare owner and manager or as the friend who's inviting someone into her home. Nonetheless, it did proximately cause it. In fact, I think there is a holding included, I believe, within Cox that the mother's allowing her to be exposed to an unknown danger, her son, who had a drinking problem, in that case, was indeed part of the proximate cause of the subsequent assault. But that's not necessary for you to decide here. This judge did not compare the specific, overly broad and ambiguous terms that are not consistent between the two policies and that would exclude anything, actual or threatened abuse by anyone of any person. That, according to Madison, would include any use of anything because it's subsumed. And indeed, in this case, they go too far. But more importantly, this court has already had to struggle with allegations of intentional infliction, with negligent infliction, with misrepresentation, didn't have to deal with the advertising injury, which is a completely separate coverage, but it's a coverage that the insurance company itself says bodily injury, injury other than bodily injury, arising out of publication of material that violates a person's right of privacy. That's not in Cox, but the disregard of Cox, the treatment of it as the elephant in the room, bespeaks to the fact that clearly it was on point. And in fact, the underlying case there went to trial and the insurance company prevailed. So they withdrew their petition for certiorari, which had been granted by the Supreme Court. Meanwhile, we were on hold in Wake County waiting for the Supreme Court's determination because the decision in Cox would finally answer the question. Now, I understand counsel's disappointment that the Court of Appeals opinion was not reviewed and either affirmed or reversed by the Supreme Court, but that leaves Cox, a published opinion, as precedent.
Well, let me ask you about that issue, and you've got about a minute before you get to your rebuttal time, so I want to give you plenty of time to discuss the impact of Thigpen on that analysis. And I'll just be blunt with you. I look at it the same as I look at a U.S. Supreme Court opinion. If something only has 4 votes, then it's not controlling law, it's just a plurality. If something doesn't get to 2 votes here, how can that be the controlling law?
Well, the concurrences there were 2 concurrences.
Concurrent result only.
That's right. I'm happy with the result only. The result only is that summary judgment was improperly granted and had to be reversed. Further, that the specific sexual molestation exclusion, in that case, because of other allegations of intentional infliction of emotional distress, such as our grooming, such as our neglect, such as our lack of supervision, meant that there was not an exclusion as a matter of law, and there was a duty to defend. Now, like in that case, they went back and tried the case, and guess what? Farm Bureau didn't have to worry about whether there was coverage because no judgment was given. I would ask Your Honor's consideration to the precedent, but more importantly, to the proper construction. And if you compare the coverage granted by these policies, each of these policies, and the claims that are asserted in the amended complaint attached to our answer, that is in the record pages 71 to 91, do the side-by-side comparison that the Superior Court judge was supposed to perform, you will come to the same conclusion as all 3 judges in Cox, and the result should be a reversal of summary judgment and a direction to Farm Bureau to defend the underlying action and dismiss the declaratory judgment without prejudice until there is a determination of whether there is even a coverage question.
Thank you. You'll have about 4 minutes for rebuttal.
Yes.
Good morning. May it please the court, my name is Walter Brock. Andrew Flint and I are proud to represent North Carolina Farm Bureau. Let me start out by saying these cases are horrible. The court has seen how many of these cases there are. And there's nothing anybody can say other than these cases are horrible. But these policies, and the North Carolina recognizes that liability insurance policies are written for the protection of their named insureds. They don't create a third-party beneficiary status. And it seems to me, implicitly in the arguments that we're hearing today, is that they're third-party beneficiaries of these policies. And this court knows that's not true. So we look to the specific provisions of the policies and the facts as alleged. And there are 2 overriding coverage bars here, 2 overriding that apply to both policies, all circumstances. Those are the fact that under the Plum Properties and Waste Management, as Judge Murphy has recognized, this conduct doesn't constitute an occurrence, and therefore there's no coverage for either the wrongdoer who intentionally committed the acts or those who are alleged to have been negligent in not supervising that. That's the Plum Properties case. The other overriding bar to coverage is the abuse and molestation exclusion. That applies to both policies equally. And as this court knows, it's just fundamental. The purpose of the court in construing an insurance policy is to ascertain the intent of the parties to the agreement. Well, we know in most insurance cases there's not a negotiated contract. There's a pre-approved form, and that is received by the insured. And so what the court does is looks to the plain language of the policy to see if the plain language of the policy provides coverage. And here, it's telling that the plain language of the abuse and molestation exclusion, the insured, the only living insured, Mrs. Kerby, was asked, did she understand that the policy excluded these claims? And she said yes. That's in the Farm Bureau's appendix at page 26 in her deposition.
One of the questions I had
Those
as I
weren't
was
my
reviewing that, just real quick before we move on from that point, is what case law is there to point to that we need to be considering her interpretation of the plain language?
I don't think I think it's just a practical point, Your Honor. I don't think there's a case law saying that, except to the extent this court looks generally at whether there's an ambiguity so that it should be construed against a carrier. And here, she understood that this conduct was not covered and that she was not covered, and she's not contesting this declaratory judgment action.
How do we deal with the differing language between the homeowner's policy exclusion and the commercial?
I think fundamentally there's not a material difference because they both focus on the injury. If you look at the homeowner policy, it says coverage E and F do not apply to the following: bodily injury arising out of sexual molestation or corporal punishment or physical or mental abuse. So this is not excluding conduct, right? It's not excluding it whether it's intentional or negligent. So whether it's negligence or not is immaterial because this policy, like the policy in Phillips, is excluding coverage for an injury due to sexual molestation or physical or mental abuse. And in the general liability policy, the language is a little different, but it really doesn't, it doesn't draw, it's not, it's a difference without a legal distinction, I would submit. It says this insurance does not apply to bodily injury. And then it addresses a property damage or personal and advertising injury arising out of the actual or threatened abuse or molestation by anyone of any person while in the care, custody, or control of any insured. And so it uses more words, I would submit, to accomplish the same thing. That's because in a commercial context, things are a little bit more complicated. You've got employees and things like that. We all know that. And plus, there are many other attempts to get around an exclusion that they have tried to plug the holes, frankly. I think it's why. But it's really the same thing. It's really the same thing. It's the injury that is excluded. It's not the conduct that caused the injury. It's the injury from abuse or molestation. And in the fundamental problem with the plaintiff's case, the underlying plaintiff's case, the Morgan's case here arguing for coverage, is that they are failing to draw the distinction between what is the injury that is precluded from the tort liability, potential tort liability of the insured in this case, Karen Kerby. They're not drawing the distinction between that. They're not drawing the distinction between insurance coverage and tort liability. And if we focus on the policy that bars coverage for the injury of abuse or molestation, then that is what is not covered by these policies. That's what the court in Phillips recognized. It was the injury of the abuse in that case. And in Phillips, the wife was alleged to have been negligent in not preventing her husband from abusing, I think it was the niece who they were taking custody of. And this court, in a 3-0 decision written by the current chief judge, wrote that it was but for the abuse, there would have been no such injury, and therefore that bodily injury is simply not covered. Emotional injuries are bodily injury, but this policy defines out of that injury due to molestation and due to abuse. So it doesn't matter what theory of liability, whether it's intentional, whether it's negligent, whatever it is, the injury for which they seek recovery is injury from abuse and molestation. As disgusting as that behavior is, it is barred, and there is no coverage for it.
Let me ask you, since we're talking about competing case law here. Let's assume that your friend for the plaintiff has, or for the defendant actually in this case, has convinced me that Cox should apply, and therefore Phillips violates in re civil penalty because it comes after Cox and says something different. Can you, if we say there is an occurrence, can you win under Cox?
Yes, Your Honor. Yes.
How do you win under Cox?
Well, first of all, Cox didn't say that the abuse exclusion did not apply to the abuse, to the sexual abuse by the son. In fact, it recognized that it basically conceded that it did, both for the son and the mother who didn't protect the child. What bothers me is the argument about what the other injury in Cox has been conflated, because if you read Cox, it wasn't that the court said, well, the one judge said, that the abuse and molestation exclusion doesn't apply to the rape. The court didn't say that. Didn't say that it didn't apply both to the claims against the mother and the son for that. It said, oh, there was other conduct that caused discrete, separate injury that we don't consider within the scope of the abuse and molestation exclusion. The providing her with drugs or something in her drink, you'll remember that, and said she got sick from that. The court pointed, now, I believe that was wrong reasoning because that had to be an intentional act, didn't it? But anyway, the court said the abuse and molestation exclusion didn't apply to that conduct. Okay. And then the mother's conduct after the rape of abusing and going to the schools and saying bad things about the young woman in the Cox case, the court pointed to that behavior after the rape as causing its own separate and distinct injury. And that is the separate and distinct injury that the court said, while I think that subsequent conduct is also intentional conduct, knowingly going to injure somebody, that's where I have a disagreement and had a disagreement. We'll always have a disagreement with Cox, but you know we've got to move on from that. But those are the facts, and those are the injuries that the court found gave rise to a duty to defend, not the injury from the rape. It's plain as a bell in there. And so for these arguments to suggest that because there was negligence, that's another cause of the injury, ignores even the case they rely on, which I submit, and the case this court has identified that I missed. Even though the case has no precedential value, the case didn't say that the abuse exclusion didn't apply to the rape or the negligence claim against the mother because she allowed her son to rape the child. It was other conduct. And so as flawed as we submit the Cox decision is, if this court were to consider it even as informative information and not binding authority, which I think we all have to conclude that it isn't, it's distinguishable on the very facts of the case. And in fact, on the narrow point of whether it supports our argument on the abuse exclusion applying to sexual abuse, both to a person alleged to have been negligent in allowing it to happen and the perpetrator, it applies to both of them. And so it supports our position. So,
you know, we sort of draw this distinction between duty to defend and duty to cover and indemnify, and
right.
as as I've always understood it, the duty to defend may be broader than the
And it's
duty to
important
cover.
why it's broader, but go ahead.
But sort of along those lines, I mean, where do we draw that line here in this case? And to an extent, isn't that maybe one of the takeaways from Cox, writ large, that maybe the duty to defend is broader than the
There's
duty
no, there's no doubt that the duty to defend is broader. But if you look at the Harleysville case, and I think, why don't we just look at the Harleysville case? Because I think it's important to understand what that means. It doesn't mean that, oh gosh, if there's some imaginable theory of liability that somebody might come up with later, that we'll find that, so therefore we'll consider it there's a duty to defend for now. That is not what that is not what Harleysville says. Let's see. I'm reading from page 7 of the official 364 NC 7. It says, thus the duty to defend is broader than the duty to indemnify in the sense that an unsubstantiated allegation requires an insurer to defend against it, so long as the allegation is of a covered injury. So it's talking about, because you have to defend even non-meritorious claims or allegations of fact that aren't true, right? That's where it's broader. It goes on. However, even a meritorious allegation cannot obligate an insurer to defend if the alleged injury is not within or is excluded from the coverage provided by the insurance policy. And I think that's helpful. But going on in that page, it says, in addressing the duty to defend, the question is not whether some interpretation of the facts as alleged could possibly bring the injury within the coverage provided by the insurance policy. That's not the question. The question is, assuming the facts as alleged to be true, whether the insurance policy covers that injury. The manner in which the duty to defend is broader than the duty to indemnify is that the statements of fact upon which the duty to defend is based may not, in reality, be true. So there's a lot of misunderstanding about that broader, isn't it? It's the facts that they allege. They may not be true, but even if they aren't true, you've got to defend, even if they're not true. Otherwise, you can deny negligence and you don't have a duty to defend, right? That would be silly. So the point is, you've got to look at the facts. And I urge this court to look at the actual facts alleged. And there are no facts alleged seeking an injury other than injury from abuse or molestation. Nowhere in the pleadings, in the multiple counts, are there any such allegations.
Now, if we're interpreting the complaint broadly, and granted, I would think, a large portion of damages would be related to the sexual abuse. But what about defendant's argument that a portion, at least, of the claim would be inclusive of those things that occurred prior to sexual molestation,
right,
and the long-lasting impacts of that, or even if it were nominal damages or some minor amount of damages from that, even though you've got the sexual molestation is a big part of it. It might be 90% of damages, but you might have this 10% to something else.
That's why I encourage you to read the complaint, because they are not alleging any separate injury like it was alleged in Cox. It's not there. They can't make it up now. And in this context, I think it's interesting. I think it's interesting that Farm Bureau didn't wait until the underlying complaint was filed in this. There was lots of assertions made in demand letters and all. So Farm Bureau filed this declaratory judgment action in January of 2016. January 2016. a lot of times, insurance coverage lawyers don't like to do that. Why? Because it creates a roadmap to coverage, right? They know exactly what the carrier is saying bars coverage, so they can try to plead around it. So it's a roadmap. But this is important enough to say there is no coverage, and there's no coverage because all of the injury is because of the abuse or molestation. This conduct beforehand, Judge Murphy, isn't alleged to have caused any injury until there was abuse or molestation. And that abuse and molestation creates what he's argued is the shame, right, and the embarrassment. But there's no shame and embarrassment from having a cordial relationship. They haven't alleged, and they can't allege any injury from that. It is only the fact that Mr. Kerby abused and molested this innocent child that they have a claim. It's the only reason we're here today, is because he abused and molested this child, and the only injury she has is because of that. But for that, in the words of Phillips, there would be no claim. There would be no injury. There would be no harm. There would be no underlying lawsuit. The Morgan complaint was filed after the roadmap was laid out in October of 2016. You can scour it. It doesn't allege a separate injurious event before the abuse or a separate injurious event after the abuse. It's not there. Going back to Harleysville, we can't imagine what they could have alleged. You have to look at what they did allege. So we look at the facts actually alleged. And you know, not only was that filed almost 10 months after the roadmap, it hasn't been amended. The underlying complaint has not been amended to, if there were any discrete injury from any conduct other than the abuse, then that could have been alleged by amendment. And it has not been. Because, I submit to you, they can't allege that under Rule 11 because it's not true. But in any event, under Harleysville and the duty to defend, you have to read the facts actually alleged in the underlying complaint and determine if there is any injury other than from abuse or molestation. And I will submit to you that there's not. And so that brings about the two overriding bars to coverage. And Judge Murphy referred to the Plum Properties case. So if we use just the analytical approach, if you start with the grant of insurance coverage as your first analysis, you look at whether the insuring agreement covers this loss. And both policies require for there to be a covered loss that it be caused by an occurrence. And as was alluded to by Judge Murphy, waste management, boy, that was back at the beginning when I was a baby lawyer. The waste management case pointed out that occurrence, includes an accidental event. Now the policies actually include that language in it. Occurrence means an accident in the general liability policy. In the homeowners, occurrence means an accident. And then it talks about continuous or repeated exposure to substantially the same harmful conditions. And so in order for there to even be an insured event, forgetting the exclusions that apply, for there to be a covered event, it's got to be an occurrence. And as Plum Properties pointed out, sexual as Plum Properties pointed out, the intentional conduct of certain persons that is not accidental is not an occurrence for them. But also Plum Properties goes further than that, because in Plum Properties, the parents of 4 children who were alleged to have vandalized 4 houses were also sued. And they were sued for what? Negligent supervision. Essentially what Karen Kerby has been sued for. Negligent supervision.
Mr. Brock, let me take you back a little bit to Harleyville, and I'm having a little trouble trying to figure out how we can use the comparison approach when, as you mentioned, they haven't moved to amend their complaint, and we have a global application for declaratory judgment, which could include amended claims, which could include future claims against Robert Kerby, and all of those things you're seeking relief from, and we don't know what those other claims or amended claims would entail. Is there any guidance on use of the comparison rule when it's not the insurance company saying, hey, we don't have to cover this lawsuit? It's, we don't have to cover any claims related to any of this or any of these parties.
With respect to Robert Kerby, he's deceased. I don't know how long he's been deceased right now, but
I think it was March of 2020, March 4.
yeah. So maybe a claim against his estate is not quite barred. That's why he was alive, obviously, when we filed the declaratory judgment action. But if they could always come forward with facts to show that there was a covered claim. We included not just the insured, but we included that person who was making a claim. If they could come forward with facts, they could allege those in an answer or in a counterclaim. That there are harms, there are injuries other than injuries from sexual abuse. They could have done that, but they didn't. They are not alleged. In fact, in one of their affirmative defenses, they asked the court to declare that I think publishing illicit photographs is not abuse or molestation. I mean, if they could have alleged any facts of any injury that resulted from other than abuse or abuse or molestation, then they were free to do that in their answer to the counterclaim in the declaratory judgment action. Or they could do it by amended pleading. Judge Murphy, I don't know how you could ever have a declaratory judgment action, there's no duty to defend, if you say, well, they could always amend their complaint. But the cases are full of such.
In Harleysville, and correct me if I'm wrong, I just may be off on remembering that. Was that a declaratory judgment that we don't have to defend the complaint filed, or we don't have to defend at all? If you don't recall, obviously we can do.
I would have to look back at it.
Okay.
I don't recall.
And let me ask what.
I'd be guessing. I don't recall.
I've got a housekeeping question that's been bugging me since we got this case. I note that the entry of default against Mr. Kerby, I believe, was entered in, I believe it was February of 2020 while he was still alive. However, no default judgment was entered
Right.
until after he passed away. I don't see where anyone either stepped in as his estate or the public administrator was appointed to represent his interest. And I guess I have a concern with the trial court exercising jurisdiction over a person and or their estate when they're deceased and no longer can appear before the court.
Yeah.
I think that was in June, a few months after his death.
So having never made an appearance and a default being entered against him before his death, then he doesn't have a right to appear. He's lost that right to appear. And we didn't enter a judgment by default against him.
Right, the judgment against him doesn't come until this same July order, correct?
That's right. The only judgment is a summary judgment. And that's because, as I understand the declaratory judgment world, there's no such thing as a judgment by default. You can get an entry of default, which bars the other party from contesting the well-pleaded facts, but the conclusions of law and the conclusions to be drawn from the well-pleading facts is a matter of law the court's got to rule on. So even if I've had a case where nobody contests the facts, I still have a summary judgment motion heard by the court, since I understand the court can't grant judgment by default under the declaratory judgment statute.
Thank you, sir.
I don't know if that addresses the court's question about that, but we
It
felt
does.
that
Thank
once
you, sir.
there was an entry default, the fact that he had passed didn't matter because he had given up his right to participate. And there was no effort for him to come back in and reopen it. And there'd be no reason for us to object to that. Even Ms. Kerby hasn't contested this. And again, Your Honor, as to Ms. Kerby, it was also just an entry of default, not a judgment by default.
Correct.
So we submit that there's not an occurrence. Therefore, both the intentional acts of Mr. Kerby are barred, as well under Plum Properties, the negligent supervision claims against Mrs. Kerby are barred because, as the court in Plum Properties says, there's no intention to buy insurance to protect you from intentional acts. Notice Judge Inman recused herself from this panel, but she was a member of that panel. And we submit that the case of Phillips does control this court. It is an established precedent. But it's also, I think, useful, though not binding, to look at the two federal district court cases, the Allstate versus Bates case, which was a same situation where a wife was alleged not to have protected a visitor from her husband's abuse. Claims for negligence against her were barred from coverage. And even in the First United Methodist Church, where there was a child acting out sexually with other children, the negligent supervision claim against the church was found not to be covered because of this same abuse and molestation exclusion. So, Your Honor, in closing, I see my time is up. I didn't imagine I would take this much. I would ask that as you hear rebuttal, you listen to whether the argument is about facts actually alleged in the underlying complaint, not some imagined theory that could be proposed in the future, because to consider those would be contrary to Harleysville. And we ask that the court affirm the issuance of summary judgment by the trial court.
Thanks, sir. Any other questions, Mr. Chan? Thanks, sir. Mr. Moore, you've got about 4 minutes. I'll give you an extra 30 seconds at the end to wrap up once the red light comes on.
Thank you, Your Honor. I join Mr. Brock in asking this court to look at what was actually alleged in the complaint in the record, pages 71 to 91, I believe it is. Because there, what you'll see is that specifically, Karen Kerby neglected Elizabeth over a course of years, long prior to October 12th of 2016, when the one incident of indecent liberties became known because Elizabeth realized that she was not being treated right, and the whole lid came off. But for years prior to that, Karen Kerby neglected Elizabeth. While she was in her care, she allowed the child to wander beyond the premises licensed as the daycare facility. She sent her outside to perform yard work with her husband and directed her into residential portions of the house unsupervised by any trained or qualified daycare employee, heedless of repeated and numerous warnings from children, parents, and the local DHHS. She arranged, Karen Kerby, doing business as Karen's Daycare, arranged for photographs and videos to be taken of Elizabeth and other children as part of the services offered by the daycare facility. then repeatedly enabled and negligently retained her husband to appropriate each child's image, exposing those children to a mentally unbalanced individual who was never even trained, employed, or supervised by Karen's daycare because she was in denial. So she should have known, but she negligently continued in this same repeated exposure to this clear harmful condition. And that is the definition of an occurrence given to us by Farm Bureau. And that is in the amended complaint. We don't need to amend, it's actually an amended complaint because they had filed the action, but we don't need to amend the underlying complaint anymore. And what you won't see is Robert Kerby's name in the caption. He is not a party. So we'll concede there was never a duty to defend anyone who had committed sexual molestation or abuse of a physical nature, but the definitions don't jibe between these two policies. In fact, they've even argued to the court below and in their briefs that the homeowner's policy is void because there was a business being operated there, when the other hand of Farm Bureau issued simultaneously the coverage at the same address, 320 East Chestnut Street, Stanley, North Carolina. And the premises themselves were covered, knowing that there was a daycare business, and yet even then they don't jibe. Now, Mr. Brock wants to say that this isn't an exclusion of sexual molestation, it's an exclusion of the type of injury. So emotional distress in a different degree by someone or some other physical injury that might be caused by a molestation or a sexual assault goes beyond. Now, there are policy limits, but what they cover is a judgment against the insured. Well, who obtains a judgment against the insured? The third-party beneficiaries, intended third-party beneficiaries of these contracts. That's the only way they'll ever have coverage. The Phillips case, they alleged that the sole proximate cause was the assault, the sexual assault. And this court, as well as the court in state capital, distinguished that and said, but for causation is not North Carolina law, it's from other jurisdictions. I would also ask the court to take a look at Farm Bureau versus Strox, not Cox, but Strox, S-T-R-O-X, I believe, 330 North Carolina, 697, 1992. And that defines accident where someone shoved another person and found that you still can't exclude it under the intentional act. In this case, what Karen Kerby did was neglect, was negligence by its definition, and was beyond the authority that she had. And she breached the trust of this young child and many others in her care, and her friend and the mother of that child. And as a result, we have absolutely alleged causation, proximate cause, and occurrence, the repeated exposure to those conditions, and please do perform the comparative test with the actual complaint, and I believe this court will be satisfied that there is at least a duty to defend.
Thank you, Mr. Moore.
And could I ask you,
Sorry.
I didn't see that V. Strock's case cited in briefing. Is it cited in a memorandum of additional authority? And if not, would you mind submitting one to our court?
I will. I thought it was, but I will certainly do that, Your Honor. I have to respond to the court's concern about naming as well, and we'll do that.
Thank you.
Thank you.
Thank you.
Yes, sir.
All rise. This session of the North Carolina Court of Appeals is adjourned.
Good to see y'all.
Yes, sir. Good seeing you again. You too. I'm sure Dick will